Saurabh. Um, Hey, Saurabh from YouTube. I got deported under Section 212A7AI or L with 5 years ban due to Apex IT system. Is Mr. Wasden's litigation, will he be able to help me?
Hopefully. Um, so right now we're building a case that we're going to be filing, and we're cutting off new plaintiffs next week at this time. And so that case is going after the question of whether or not the government is required to give you notice and an opportunity to respond prior to entering the fraud finding. And the reality is, like I said earlier, before you hit the port of entry, you had a fraud finding in the system, and all CBP was doing was just rubber stamping USCIS's fraud finding when they turned you around. So our approach on this is not to argue whether or not you are innocent of fraud or guilty of fraud. We don't want to be dealing with the factual merits of the case. We want to be dealing with the procedural merits of the case. Did the government follow the proper procedure before they took action against you? The good news is, in my line of work, procedure, I'm an administrative lawyer, so we practice under the Administrative Procedure Act. And if you can point to a procedure that's been violated, courts are far more interested and likely to rule in your favor. If you're arguing about the facts, you're losing at that point. So we have a pretty strong argument that's on the process and the procedure. And then we're going through and we're taking those clients with the best stories to tell. That it's absolutely clear through their story that they did not commit fraud and yet have been penalized by the agency. The thought being in a large group case like this, you kind of can pick and choose how you're going to tell the story of your case, because you have a lot of co-plaintiffs with a lot of different stories to tell. So it's doing these group cases has a lot of distinct advantages.
All right, so this is something you're referring to, the class action lawsuits that you've been filing?
Mm-hmm. Yeah, so we've got one in Seattle. It's not a class action. It's more of a mass action or a group case. For a variety of reasons, class actions are not my favorite way of doing business. Mostly because they're slow and they're very expensive. And so if you want a quick resolution to a problem, avoiding the class action is definitely the way to go. But the first one that we filed was in Seattle with a group of plaintiffs, and most of these plaintiffs were outside of the US. Some of them were still in the US. Of the ones that are outside of the US, we're getting notifications constantly from our clients that the consulate has stamped their visa where before they're in 212 or 221G, and they've made it into the country. They made it to the port of entry. So that's, I think, a positive sign, and I think it's an indicator of how weak the government thinks their case is.
Okay, when you said, the consulates have, if I take an example of a student, let's say they pay $20,000 to a university, right? And then they get a visa stamped. They attempt to first time admission. There are not too many cases where they were denied the first time admission, or they were here, they continue to pay the fee, and let's say whopping $30,000 or $40,000, and they, for personal reasons, they travel out of the country, and they suddenly become inadmissible. So what happens to this money that was paid to these universities who don't want a refund? Is there a way they can at least get the money back, because they take high interest loans back in home countries and pay these, so sometimes it's fictitious universities or online universities, just like the question we've had. So would this also be a part of litigation to send a subpoena to the university to get at least collect the money on behalf of the students?
So a debt collection action like that, and really in a case alleging fraud, is really something that is going to be specific to the state where that college is located at, and it's going to follow the state's law. I do federal law only. I don't really do any state law. So because my practice is all federal, it wouldn't be something that we would do. But if you have a large number of people that are impacted, a plaintiff's attorney would love to take that case because, yeah, they work on contingency. They don't get paid unless they win. And if there's a lot of people that paid a lot of money, there's a lot to win.
Okay, thanks for that.
Are you an IT consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.